You brought a lawsuit against someone who you believe was careless, who caused you significant harm and injury. And now, throughout the course of the litigation, the defense has refused to negotiate. If the defense now makes a settlement offer, does your attorney actually have to call you and discuss that offer with you? Or can he settle the case on his own without involving you and getting your input? You want to know the answer? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is, any time a settlement offer is made, in New York, your attorney is required to contact you to discuss with you the fact that a settlement offer has been made. Your attorney is required to discuss with you the risks of not accepting that offer, as well as the risks of accepting the offer, meaning what's the significance of that to you if you agree to the defense's settlement offer. So let's go back to the question I just raised. Can your attorney go ahead and settle your case without any input from you whatsoever? The answer is no, he can't. He is not permitted to go ahead and settle this case. Why not? Because it is not his case to settle. It is your case. You, the injured victim, the injured patient. You are the one who controls whether or not your case is settled based upon a settlement offer. You are the one who has the final say. Your attorney is going to offer you his experience, his knowledge, his suggestions as to whether or not the settlement offer that's been made is an appropriate one and represents full and fair value for your injuries. Your attorney will have to explain to you exactly what's going to happen if you reject the offer, and now you proceed to trial and now rely on a jury to decide your fate, to decide whether or not you are entitled to receive compensation, money as a form of compensation, for all the injuries and harms and losses you suffered because of someone's carelessness. But under no circumstance that I am aware of, and I've been doing this now more than 30 plus years, can your attorney go ahead and agree to settle your case without discussing it with you. However, there is one exception, one, only one, but it involves your input. It involves an extensive discussion with you. So let's say your attorney calls you up and say, listen, I've been having some settlement discussions with the defense lawyer. Here's what they think this case is worth. Here's the amount of money that they have, and here's where I think they are going. Now, your attorney can go ahead and tell you about all that. That doesn't mean that a settlement offer has been made yet, and it doesn't mean that the case will be settled. However, your attorney still is not permitted to go ahead and agree to any settlement offer until and unless he has your consent and your permission. Now, if after discussing the various options, if after discussing what could happen, what might happen, what will happen, your attorney says, listen, I think they're going to offer $3 million, okay? And I think if they come back with anything above $3 million, you should take it. If you agree to that, even though they have not made the actual offer yet, your attorney has already spoken to the defense attorney and now is trying to get a sense of exactly where they're going and what they think this case is worth. And he's trying to push to get as much as possible for you. If after that discussion you consent and you agree to accept anything above a particular number, now when your attorney speaks to the defense lawyer and now they have a further discussion about an actual offer, if they come back with anything more than the number you agreed to, yes, in that instance, and that instance alone, your attorney would then be able to go ahead and settle this case on your behalf. Why? It's because he's already obtained your consent, because you have already acknowledged and recognized and agree with his suggestion and his strategy that if they came back with a certain amount of money and anything above that, your answer is, yes, I will settle for X number of dollars and anything above that. In that instance, now you have given your attorney express permission to go ahead and accept the settlement offer, anything above those numbers, so that now you are fully informed. Now you've had a clear understanding of exactly what's being offered or what likely will be offered. And now you are also aware and familiar that if the defense comes back and offers you less than the number that you and your attorney agreed to, now you know that your attorney will not settle your case for that number. So that is the only instance that I can think of in which an attorney can go ahead with your express permission to go ahead and settle a case. But If he fails to discuss with you the various options, if he fails to tell you about a settlement offer, under no circumstance that I am aware of can your attorney then go ahead and settle the case on your behalf without your input. So why do I share this information? I share this information because many injured victims, many injured patients are concerned when they bring a lawsuit. Is my attorney ever going to settle this case without my input, without talking to me first? The answer is absolutely not. Your attorney is under an ethical and moral obligation to go ahead and talk to you and explain to you about any settlement offer that is made on your behalf, so that ultimately you, the injured patient, the injured victim, will now have the ultimate say about whether or not to go ahead and settle the case. Why do I share this with you? I share this with you to open your eyes, to explain to you exactly what occurs when the defense actually makes a settlement offer. Or they now talk to your attorney and now have discussions about the value of your case and where they think this case is going, whether or not they think this case can be settled, and if so, what the range of the settlement amount should be. In that instance, now your attorney has a conversation, you agree or disagree, and now your attorney can proceed forward knowing full well where you stand in order for him to make an educated decision about whether or not to go ahead and accept or reject the defense's offer. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.